to process my loan application and only provided terms that will benefit them, from high interest rates to several bank fees and even shortened loan repayments. But then I visited the Cannings Credit Union, and boy oh boy, same day I got approved for my vehicle loan and low interest rates and terms that will only benefit me. Now, don't get me started with the high level of professionalism to which they handle my loan application and the caring heart of the loan officers who ensure that I was driving within 1 week. You know, you can tell if an organization has been set up to care for you, and the Cannings Credit Union is one such organization. They care for you to help you achieve your dreams and financial goals. And I would recommend the Cannings Credit Union to anyone because if they can do it for me, they can also do it for you. This is my SecU story.
This is just one of our Secu stories. We invite you, our members, to send us your Secu story and become part of our legacy.
Enough to be assisted purchasing cars, sending my children to school, my grandchildren, they're also members, and a lot of other financial opportunities that I'm grateful for. This is my Secu story.
This is just one of our Secu stories. We invite you, our members, to send us your Secu story and become part of our legacy.
Hi, my name is Ryan Lachu, and I've been a member of SECU for just about 20 years. SECU has been instrumental in helping me plan my financial future from a suite of products including dividend accounts, mortgage management, and insurance services. The team at SECU has proven time and time again that their customer experience and advice is second to none. This is my SECU story.
This is just one of our Secu stories. We invite you, our members, to send us your Secu story and become part of our legacy.
Hi, my name is Stacey Simon Inns. I am a member of the Cannings Credit Union for 17 years. I started saving with the credit union at a very young age when I was employed at Tyler Food Stores, now Massey Stores. I have three kids who became members at a very young age, which benefit from the FDA grants, the financial literacy program, and the pet bookshop. I also have my family, my mom and my in-laws, who joined the SIP plan and they had benefit from it. Buchanan's Credit Union are not just for loans, but it's for the entire family. This is my secure story.
This is just one of our Secu stories. We invite you, our members, to send us your Secu story and become part of our legacy.
Hi, my name is Crystal James. I have been a member here at SecU for 12 years. I was joined by my mother, yes, at a very young age. By being a member here has benefited my family and I greatly. At the age of 17, I was able to open my very own business just by having a savings here at SecU. At the age of 23, I was able to purchase my first car. But unfortunately, this 2024 year, I got into a tragic accident and I had to restart my loan process all over again. But let me tell you, the procedure was very fast and smooth with no issues. I am very happy to be a member here at SecU. This is my SecU story. Bye.
This is just one of our Secu stories. We invite you, our members, to send us your Secu story and become part of our legacy.
Hi, I'm Patrice Cotine and I've been a proud member of SecU for just over 11 years. I started off with a savings plan under their shares program. This was my entry point into the services that they offer. My family has benefited from being part of their group medical plan, SecuCare. 2 years ago, I was finally able to purchase my very own dream home. This was made possible because at the time, SecU had an unbeatable mortgage rate and probably still does. Thank you, SecU, for making my family's dream come true. This is my SecU story.
This is just one of our Secu stories. We invite you, our members, to send us your Secu story and become part of our legacy.
Good evening, everyone. I would like to thank you for joining today's session on time. I am just going to ask for 2 minutes of your time so that we can allow other persons to join. Thank you for your patience, and you will see me back in about 2 minutes at 5:34. Thank you.
My land and my home. My family members are also SecU members. I've also benefited through FIP in time of need to address my funeral expenses. This is my SecU story.
This is just one of our Secu stories. We invite invite you, our members, to send us your SECU story and become part of our legacy.
Hi, good afternoon. I'm Jan Rapia, a proud member of Finance Credit Union, also a member of staff for the past 20 years. Finance has been financially supportive to me and my family. I was able to open accounts for my siblings and my young daughter so they have a financial future ahead of them. This is my SECU story.
This is just one of our SECU stories. We invite you, our members, to send us your SECU story and become part of our legacy.
Hi, good day. My name is Michael Fordringham, and I've been a member of the Cannings Credit Union for 7 years. And you know the saying, the grass looks greener on the other side? Well, it appears so because it's fake grass. Let me explain. This year I acquired my vehicle, and the vehicle dealer referred me to 3 commercial banks to which they deal with. Well, I visited and I applied. Those commercial banks took almost 4 weeks to process my loan application and only provided terms that will benefit them, from high interest rates to several bank fees and even shortened loan repayments. But then I visited the Cannings Credit Union, and boy oh boy, same day I got approved for my vehicle loan and low interest rates and terms that will only benefit me. Now, don't get me started with the high level of professionalism to which they handle my loan application and the caring heart of the loan officer who ensured that I was driving within 1 week. You know, you can tell if an organization has been set up to care for you, and the Cannings Credit Union is one such organization. They care for you to help you achieve your dreams and financial goals. And I will recommend the Cannings Credit Union to anyone, because if they can do it for me, they can also do it for you. This is my SECU story.
This is just one of our SECU stories. We invite you, our members, to send us your SECU story and become part of our legacy.
Okay. Good evening again, everyone, and welcome. Thank you so much for taking time to register and attend our webinar today. I know how busy you are, in fact, how busy we all are, but we truly appreciate your participation and your time for joining us this evening. My name is Paula Marcel Irish. I am a director on SECU's board and the chair of the Education Committee. I would also like to extend a warm welcome to other members of the board of directors here joining. I saw Mr. Marajon. I would also like to welcome other members of the Education Committee, our dedicated management and staff at SECU. Today's webinar will be on planning for tomorrow, essential steps to safeguard your legacy with estate planning, wills, and probate. For me, this is very interesting because every time we have a session on estate planning, I seem to hear some new scenarios and very interesting cases around wills, probate, and of course, estate planning. Many people, and I don't even want to say the elderly, put off creating a will as they always think they have time. But what happens when someone dies without a will? There is family infighting, chaos, despair. Families may disagree on how assets should be divided. This often leads to conflicts and disputes among relatives. It may cause rifts within the family and may result in lengthy and expensive legal battles to resolve the distribution of the estate. Additionally, the estate has to go through probate when there is no will. This can be a very time-consuming and complex process. The court then has to appoint an administrator to oversee the distribution based on local intestacy laws, and this can take months or even years, which delays access to the inheritance and causes financial stress for beneficiaries. Sometimes intestacy laws may not reflect the dead person's wishes, and this can lead to unintended consequences. For example, assets might be divided among family members who were not even close to the deceased, while other loved ones, maybe stepchildren, unmarried partners, or even friends, may receive nothing. This, of course, can create further emotional distress and complications to those left behind. It is from that perspective that we continue to host webinars on estate planning. In today's session, you will hear about the importance of having a will, choosing an executor and the role of the executor, the estate planning process, and what we should consider when distributing our assets. We will hear about some common misconceptions about wills and estate planning and the probate process. I'm sure many of you are quite familiar with webinars, house rules, but this is just a reminder. Please ensure that your mics are muted throughout the session. If any questions come to mind during the session, please either place them in the chat box and we will respond to them during the question and answer segment at the end, or you will be allowed to come off mute at the end and ask your questions. This webinar will last for 90 minutes. It will be recorded, so you will have another opportunity to listen again. And it will be uploaded in the library section of our website. Our presenter today is Mrs. Indira McFarlane Lee. Indira is a qualified attorney at law with over 20 years experience in corporate governance, probate, arbitration, litigation, conveyancing, and real estate development. Indira also has considerable experience in project development, contract management, and administration of over $5 billion in construction and engineering projects. She is currently the governance officer and the corporate secretary of the Massey Energy and Industrial Gases Business Unit. I encourage you, let us listen attentively to what Indira has to share this evening. Let us engage, let us participate, ask questions, because I am sure that you, like me, have many different scenarios that you keep encountering all the time. So thank you again for joining. Indira, over to you.
Hi, good afternoon, Paula. Good afternoon, members. Paula, many thanks for that introduction and putting what our intention and what we hope that our listeners get out of it into that context. Thank you so much.
No problem. I'll see you after. Yes.
Yes, see you after. So members, sometimes thinking about what's going to happen to our property when we pass away might be difficult. You know, some people might think it's bad luck. You know, I do a will. Am I bringing death upon myself? You know, I don't have time. It's too complex. And I hope that by the end of this presentation and our session this afternoon, that you have some information that is useful and that you have some food for thought. So I'm just going to share my presentation right now. Everyone seeing the presentation?
Yes, Indira, it's up.
Excellent. So moving right into it. First of all, this presentation is really just for your general information. If you have specific issues that you need legal advice on, please go to see an attorney. Right? Don't do some action and say you heard this information, you got advice from a webinar. Okay, guys? Right? So these are the objectives of the presentation. So because we call the presentation estate planning, this is just what estate planning means, right? It's just that you make a plan as to how your wishes, as to how, what will happen to your estate, which means your property, and it could happen, you know, before or after death. So distribution of your estate can happen before or after death, right? So it have legal terms, right? You hear about real property or personal property. Real property is basically anything fixed, right, to the ground, like your land and building. Personal property is everything else. So when we talk about estate planning, we have to be mindful that your estate, which is everything that you own, can be distributed while you're alive, right? Under what we call a testacy, which means you have a will, right? And it takes place after death, or under intestacy, which is after death, but you have no will. So let's get into, you know, some of the reasons why we should make a will, right? Some misconceptions about making a will and some considerations when we decide to make a will. So why should I leave a will, right? Basically, a will is a document, a legal document, in which a person states their intentions as to what should happen to their property after their death, right? And it is to be prepared and executed in accordance with certain legal formalities. We have legislation which dictates this is how a will is to be legally executed if it is to be recognized by the law, right? But most important of why I should leave a will is that you get to decide who gets what, right? And how much, right? As Paula would have indicated previously, when you don't leave a will, the law says, right? The law says who gets how much of your estate. By having a will as well, you decide who will carry out the wishes in your will, and this person is called an executor. So what are the requirements for a will? So the will has to be in writing, right? You cannot speak, you know, tell somebody, right? And you can't just write, it's not something you just write in a book or on a piece of paper and you say, here, this is my will, right? But it must be in writing, right? You must be 18 years of age. You must have the mental capacity when you are making the will. The will must be signed by the testator, that is the person who's making the will. The signature should be at the end of the will. The testator must sign his will in the presence of two witnesses who must both be present when the signature is made. And then the witnesses must sign in the presence of the testator. So basically the three people are physically in the same space. That doesn't mean that your witness has to read your will or know what's in your will, but they must witness you signing the will, and you basically must witness them signing the will. Yeah. Important. You cannot have a beneficiary who is a person who you give a gift to under your will witness the will, right? This will make that gift void, right? Or nullify that gift. Some important points. A will takes effect upon death. So what we mean by that is that I could leave, say, my blue, CRV, right, to my daughter in my will. When I pass away, 10 years from now, I may have sold that blue CRV, right? So my daughter no longer has entitlement to that blue CRV, yes? So that's what we mean by the will takes effect upon death. So whatever the testator owns, so the testator can only give away what he has when he has died, right? So sometimes when people haven't updated their will, sometimes by the time they have passed away, a lot of what they may have had in original will no longer exists, yeah? Wills can be revoked. That means you can change your will. It's not set in stone, right? Please note that if you have a will and if you get married, that will is automatically revoked. So you would need to do a new will. But please note, if you get divorced, it doesn't mean that new will has been revoked. So please be mindful about that. Fraud or undue influence will invalidate a will. Yes, so I mean, it goes without saying, and this is illegal, right? So sometimes we see instances and matters go to court where family members will say, you know, mommy did not execute this will under her own free will. She was sick. She was too sick to understand what she was doing. She always signed a name. Why is this thumbprint here, right? So generally speaking, when I have to do a will for an elderly person, yeah, I ask them to go to a doctor and have the doctor certified to their mental capacity. So that protects the testator in case anybody wants to come and say, you know, this person could not have made this will because they were not of, you know, sound mind, or, you know, this person was unduly influenced. Generally speaking as well, if I have to take instructions from a person making a will, I take those instructions with the person alone. Nobody, your daughter could have come, your niece, your nephew, but the instructions should be taken one-on-one with your team. Yeah? Because you want to make sure as well, right? And so if you're the person going to, that there's nobody around, right? You should be free to express what your wishes are, to answer freely any questions as well, right? This also, what it also does for the person taking the instructions, they can say, yes, I got these instructions free from any influence, right? Which was apparent to them. Okay, so considerations in preparing will. Now you would have, you know, I've been speaking as if, yes, you have an attorney prepare the will. It's not legally required, right? Once you conform to the requirements of the legislation as to how a will is to, you know, the requirements of the format and execution of a will, it will be valid. However, right, my strong advice is to have an attorney prepare the will. You don't want to make a mistake. You don't want to use Google to do your will either, right? We have specific local legislation regarding preparations of our will. Yes, but it doesn't mean, like I say, that if you prepare a will and it could, once you comply with requirements, it will be legally valid, right? When preparing a will, have a list of all your assets, right? And these are not assets which are jointly held. So for example, if you own a home and that home is held jointly with your mom or your husband or your sister, what will happen is upon death, it will go to that other person. So you cannot include that assets in your will, right? And you should also know, okay, for whatever assets I have, who are the people I am going to give it to, right? You'd want to think about who are your executors, yeah? And we'll go into, you know, the role of an executor, but basically the executor, as we said, is the person who will carry out your wishes in the will, and the beneficiaries of your residuary estate. Residuary estate is everything else that you didn't include in the will. So it might include property or any assets which you may have gotten after you made the will, for example. Yeah. So I think, sorry, second point, when I said name beneficiaries, For example, if you have an insurance policy and you have a named beneficiary, well, you don't need to include that insurance policy in your will. Yeah? And then an advantage for parents with minor children, in a will, you can name the guardians of your minor in the will and it will take effect. Yeah? With respect to when your will is prepared, please secure your will. I always advise, make a copy of your will, let your executor have a copy of your will, right? You can also lodge your will in the High Court registry. And upon your passing, there is a process for withdrawing it, right? But you don't make a will and don't tell anybody about it. Yeah, don't make a will and you put it and nobody can't find the will. When you are giving instructions about your will, please consider when you have multiple beneficiaries, for example. So you may have one home, you may have many children, and we want to, in fairness, we will say, listen, I'm leaving my home to, Mary, John, James, Peter, Mohan, in equal shares. But we have to think about it and be practical about what we want to do. Some of them may not live here. For example, they may have their own families. By the time you leave that property among 5, 6, 7 people, what is to become of it? Yeah. Sometimes what happens is that some people don't take care of the property. They're not contributing to it. There's disputes about, for example, who is to live in it, because sometimes we have properties where we have some of our children still live there, some of our children and their families, right? So one consideration may be to leave the property on trust for sale and divide the proceeds equally. But it's up to you, right? And it's up to your family and your family arrangements. But sometimes just leaving something because we want to make sure that everybody gets an equal share, sometimes the consequences are not what you intend. Sometimes you see properties around and they're dilapidated and you wonder whatever happened. Sometimes it's because, beneficiaries could not have agreed as to what is to happen to the property. Yeah. Or like I say, sometimes they don't live in the country, right? Or those who are in the country can't afford to maintain the property. Yeah. So just a consideration. What we see a lot too in our country is where we own property, but we don't have legal title to it. And that could be lands which are for regularization, for example, or what we call rented lands or tenanted lands. But even in those cases, yes, you can leave what you will call your rights and interests in the property in a will, right? So even though you don't have the deed to it, you can leave that property. Well, your rights and your interests. That's how we would describe it in the will. Yeah. Right. Joint tenancy and tenancy in common. When we prepare a will and we leave, say, our house in Pitty Valley to, Betty and Mary and Susie, and we don't say as joint, and we don't say how, right? The law is going to interpret it that you meant a joint tenancy, right? What is a joint tenancy? It means that the beneficiaries you name will own it, right, together. But as each beneficiary dies, the ownership goes to the surviving beneficiaries. So if Mary dies first, her share doesn't go to her, say, family, right? It will go to the other 2 sisters. Similarly, Betty dies next, it will end up going to, I don't know what's the last name, but say Samantha and her family. Yeah. So if that is not your intention, when you recite, you would say, or you give instructions that I want to leave this property to my daughters as tenants in common. Yeah. So it will depend on your circumstances and how you wish to see that property distributed. Yeah. Okay, I have where the property is located. I am dealing with a matter where the testator, he resided abroad and he made a will in Maryland, right? He left what he had to his wife. The only thing was, the only property that he owned at his death was 3 insurance policies because he had a estate on it, right? So there was nothing in the States. And then when we tried to have that will probated here, there were so many issues, right? Because we have certain requirements when you have to probate a foreign will. Yeah, and what happened in the end, we had to end up withdrawing the application because I'm not going into it, but basically it could not comply with the requirements of our legislation, right? So if your property is in Trinidad, have your will made in accordance with the laws in Trinidad and Tobago so we can probate it here. The other issue, and we'll get to that, was that it was insurance policies. He should have put his wife's name on it. Yeah, then there would have been no need to have a will probated. Yeah, and then the other thing was, I mean, the values of the insurances were pretty small as well. So when you look at, having to engage an attorney to, apply, right, for probate, it could be prohibitive. Yeah. Right, the role of an executor. So we see an executor is a person who has the responsibility for applying to the High Court for a grant of probate. That grant of probate gives that person legal authorization to stand in the shoes of the deceased, right? Or the estate, right? The testator has to pay any debts, any expenses of the estate, and of distributing the estate in accordance with the wishes in the will. The executor also has the power to bring actions in the name of the estate or defend actions, that is, lawsuits, for example. Yeah. Your executor should be over 18. It should be somebody who you trust, ideally to be younger than you, right? And at least maybe a 0.2, right? In case something happens to one executor, say if one passes away. I would advise that when you are making your will or before you make your will, you discuss with the intended executor that you intend to make this person your executor, right? And make sure that they're comfortable and they agree to do it, right? As I said before, you would, provide a copy of the will to them or inform them where it's located. If the will has been revoked, you let them know, right? We have instances, for example, we have had instances where an executor has a duty to probate the will, right? But there's an issue as to, the cost of probating the will. And so you may want to think about how can you provide for those expenses for your executor to probate the will. Some cases, if your executor is also a beneficiary, it would be in their interest. So sometimes they try to find those fees to, to get it done. But there are cases where executor is an independent person and you kind of put them in a position, if the beneficiaries don't want to contribute, of trying to find expenses as well. And sometimes the beneficiaries themselves, right, may not be in a position to pay those expenses. So if we go into some, misconceptions about wills, right? I'm not doing a will, it's expensive, it will take too much time. Wills, I think nowadays, a will might start at maybe $1,500 to prepare. You have a basic will, but you can find out, right? But it's not expensive, right? And it could be a lot more expensive, time consuming if you don't prepare a will, you don't leave a will. Yeah. It doesn't take much time. You go into your attorney, you will give them the instructions. They will ask you to come back in. They will ask you to review and then you execute and that's the end of it. Yeah. Only the rich need to do wills. No, right? You don't need to have heaps of money and property to do a will. Remember what your will is? the purpose of your will is to say, listen, this is what I want to happen with what I have, whatever that is. Yeah. I am too young for a will. You're never too young to do a will, right? And then especially too for some young people who may have some assets, but they may not be married, right? Their parents may not be alive, for example, right? So you want to make sure that even if you are young, that if something, God forbid, happens to you, that, people who you want, who you care about in your life, can benefit from what you own. Another thing with being young and doing your will is that, you ensure that you can do your will. I don't know if that makes sense, right? Because I've had cases where family members say, gosh, daddy has a stroke, can we do a will, right? But you can only do a will if you have the mental capacity to do it. It's too late when, some mental illness has set in, for example, to go to an attorney to say, hey, my mom or my dad wants to do a will. Okay? Some people say, no, I don't need to do a will. Everybody know who gets in what, right? That's not a will. It's not legal. It's not enforceable, right? And as Paula said, it could lead to a lot of contention, right? Because they could say, well, daddy told me that I was getting this, right? Or mommy said this, yeah? But that has no legal effect. Right? Another common misconception is that entitlement happens upon the death of a testator. So you may have been left something in your will, but when the testator, when your relative or the testator has passed away, you can't go and take their car. You can't go into their home and take up whatever it is in the will, right? It has to go through a process of being probated, and then the executor will then distribute it when he has that document in his hand. Real property, so that's your home, land, has to be done by a deed, which we call a deed of an assent. So that's a legal document. And only when that deed of assent is executed that you will be entitled, you will then own that property which was left for you, right? Neither does the executor have the right to, upon the death of the testator, start to use the property or deal with the property, give it away without that grant of probate. Okay, there is no what you call interest which passes an executor or the beneficiaries right upon the death. And this applies if you have a will or if you don't have a will. Okay. We spoke about this. The wills are not irreversible. You can change a will, and always encourage people as your life circumstances change, that, as you have children, for example, or your children have grown up, right? For example, if your financials, you have more property than you had before, you may want to consider changing your will. Or if there are things, there are assets now which you want to use for yourself, right? You can do that, and then you change your will to reflect, okay, I don't have this anymore, for example. Right, so this other point, a beneficiary loses entitlement if they die after the testator but before distribution. You may have a case where a will was prepared and property was left to several persons, say several children. Before that will could be probated and the assets distributed, one of the children passes away, right? And this does not automatically mean that he or she loses out and the property then goes to those who are alive. One, it will depend on how the property is left. As I would discuss before, if it's a joint tenancy, well, yes, it will then go to the other remaining surviving children. But if it was left as tenants in common, the child who has passed away, their estate, their family, for example, their beneficiaries will now become entitled to that person's share in the property. Okay? Right, wills do not have to be registered to take effect. As I said before, there is an option that you can register your will at the High Court, right? But it doesn't need to be, right? A will is effective once it meets the legal requirements for execution under the law. Yeah. Right, so let's talk a little bit about when you don't have a will, right? When you don't have a will, the law says who gets what share of your estate. The law will also say who has the right to apply for your estate, which is called letters of administration. So under our law as it is now, if you pass away and you are married, say you're married with no children, but then your spouse gets everything, right? If you are married and have children, your spouse gets half and your children get the remaining half. If you are not married, but your parents are, and you have no children, but your parents are alive, it goes to your parents. So, and it goes on and on, right? If you have no parents, have grandparents, it goes on to nephews, you know, so the law actually sets out, you know, who is entitled, who would be entitled. So, so when you're, you know, when you leave the session to start thinking about, you know, what would happen in my situation if I don't leave a will? And you know, Paula made a good point. There are people in your life you may want to provide for. I have a colleague who she's, you know, she was never married, doesn't have children, right? She has two parents, but you know, she also has a brother who has special needs and she wants to make sure that he is provided for example. Yeah. We have instances as well where there are people who did not divorce, but have separated, have gone on to have, say, another partner, right? But what happens when that person passes away without a will? Yeah. The wife, the legal wife, is the person who still has the right to apply for the letters of administration, and she will still have a right to half to the whole property if he didn't have children, or half if he does have children. Yeah, so you have to consider what your circumstances are. For some people, they may be okay. They may be okay if I pass away, half to my husband, half to my children, or everything to my spouse is fine. Yeah, so it depends on your personal circumstances, but just for you to, you know, after this session to think about what will happen to what you own and if that is what, you know, you want. A little about common law relationships, which, you know, tied into what I just discussed. The law had, there's I think a Cohabitation or Relationships Act. Many years ago it was passed, but it only applies to when both people are unmarried, right? And those circumstances, the common law partner upon, you know, the death of the common law spouse can make an application to the court for entitlement to the person's property. But that person is not entitled to take out the letters of administration, right? So while it offers some protection, it's still, you know, it doesn't offer complete protection, right? So depending on your circumstances, you need to think about that and why making a will might make sense in those circumstances, right? And then of course, you know, there are requirements, right, for applying. It is a formal application that you have to make. It has to be made in a certain period of time as well. You'll have to get a lawyer to do it. Yeah. Right, so you can also distribute your estate while you're alive. Yeah, or take steps while you're alive to determine what happens upon your death. Right, and of course, if when you do this, well, you could be sure that what you wanted to happen to your property does happen, right? It could reduce conflict because when you pass away, well, you give away everything already, right? So nobody could be fighting over anything that's left. reduce, administrative burden and expenses. So the need, say, to probate a will or do letters of administration. Yeah. So what are some ways we can do this? You can do it by a deed, for example. So if you own a home and you are pretty certain that, listen, when I pass on, I want my 2 kids to own this home, you can do a deed to join them as owners, right? You could do a deed to say, I'll be the owner during the course of my life, but after death to Sally and Sue, right? And then when you pass on, Sally and Sue have nothing to do. That deed is their title. They don't have to do any probate, yeah? Or letters of administration. Similarly, with doing a will, consider whether when you are, conveying the property, you do it as joint tenancy or tenancy in common, yeah? Life, right. A life tenancy, for example. So that's what I just spoke about, meaning I convey it and I say, I own this property for life and afterwards to my kids. The other way is to make yourselves all joint. So you give a deed of gift and you just put the gift back in the 3, your name and Sally and Sue's name, right? But what happens then is that they actually become owners right away. Yeah? And there are implications for that, right? You may have joint accounts, yeah? But now the banks, at least some banks, require that these joint accounts are either or joint accounts. So they are not joint accounts where both parties have to sign, right? They are joint accounts where either party could sign. If you have those kind of joint accounts, upon your death, the other person becomes the owner, right? And I know we have these arrangements very common here, right? So you may want to consider it. It all depends on your circumstances. Yeah. And of course, the benefits are that beneficiary has immediate access to, the funds in that account. That might be useful as well if you have to, say, pay for, to funeral expenses or to, do the probate of your estate, etc., or pay any bills, etc., things like that. Insurance policies, right? So might be useful to name a beneficiary. Yeah, so that way, you don't have to, because some policies give you the option, you can't put estate, but then you have to probate it, right? And it will go through that whole process, right, upon distribution afterwards. Whereas if you name a beneficiary, that beneficiary gets paid right away. But a note on insurance policies, and I mean, if you have taken out insurance policies or you are going to, or maybe you need to ask your agent, it's important to know that while making the application, you named a spouse or your children as the beneficiaries. So that's before the insurance policy got approved, you will need their permission to make any changes or to assign your policy, right? Change your beneficiary. So a lot of agents will advise that you put your estate on the application. When the policy is approved, then you change the beneficiary. So when you do it afterwards, then you don't need any consent to change. Issue 2 is if you do that, if you have put, say, a spouse, right? Before the policy was approved and you need their permission to do anything. If you get divorced, that doesn't change your position. Yeah, so and it's been an area of a lot of contention on insurance policies. Yeah, so if you're not sure, you can ask your agent as to what your situation is under your insurance policy. But an insurance policy, I mean, it's a really useful way, by naming a beneficiary to ensure that, listen, that policy will go directly to that person. Yeah. And then, of course, we could just get rid of our belongings, physically distributing them, right? There are a lot of things that we don't need, or we don't use anymore, right? We have our jewelry, we have it locked up in our closets or under the bed, encourage people at a time, that maybe you can just give it away, or there are other things that you may have and you want somebody to you want them to have it, and you can, just give them it, right? Well, some disadvantages, if you give away some things, you can't get it back, right? So for example, for deeds, right? If you have given a deed of gift of your property, you will need the person you've given that, the co-owner now to consent, because they'll have to sign back their interest over. So you have to be careful too, right? Yeah, so you really have to, well, you will know your circumstances as well. But that has happened. I've had a case where somebody they did give somebody, part of a property, and then they wanted to take it back. Yeah, so okay, well, we are done. I hope I didn't rush it too much, but I wanted to leave enough time for, well, questions. Or I don't know if it was too long. Paula, over to you.
Thank you, Indira, for taking us through that. In many instances, I must say it was a good reminder. For me personally, some things came up that I just wanted to comment on. We have 2 questions so far in the group chat, and I do encourage members to place their questions. Hopefully they would have written them down and they can place them there so that we can get them answered. So it is very interesting for me, Indira, when you mentioned that the beneficiary cannot witness a will. That was new information for me. So it means, for example, if someone writes a will and names a number of beneficiaries depending, then neither of those beneficiaries can be witness to the will. First time I am hearing that, so thank you for that information. I have a personal situation that I can share, and it came to bear when you said that wills take effect upon death. So one of my aunts, she passed away, that was in 2018, but she had prepared a will in 2015. She did not have any kids, so she left her, whether it's the funds in the bank account, she put all these beneficiaries, nieces and nephews who got credit union accounts or bank accounts, etc. But because she was still alive, I mean, those were the accounts that she was using, and by the time she passed away in 2018, there wasn't much money left in those accounts. But the named beneficiaries, who happened to be my cousins, there wasn't fighting, because they started making accusations that I went into the funds and that sort of thing. So I was happy when you mentioned that the wills take effect upon death. So anyone who has already prepared a will, and it should be clear that until they pass on, then the beneficiaries may end up with nothing, depending on if it's funds in an account, etc. The other thing that was quite interesting for me is when you mentioned that you need to list your assets, but it must not be jointly held. It's not a jointly held asset in a will. I don't know if I have that correctly, but what I want some clarification on is on married persons, because I was informed that once you're married, you have to do one will, a joint will, as opposed to individual wills. Is that correct?
No, that's not correct. So I've never heard that. I mean, I've heard of joint wills, but it's not a common practice as far as I know. Yeah. And if you're married, you can do your individual will. Yeah. I mean, when I had done my will, and then when I had my first child, I changed it. And then when my husband and I were traveling, I had to redo the will to kind of say, well, if my husband predeceased, because, you leave something to your husband, but if my husband predeceases me, I wanted to go to my sister, right? Or I need my sister as the guardian for my child as well. So there's no requirement for a joint will if you are married. Yeah,
Okay, I'll definitely look into that because I was trying to understand, for example, you did mention property. So if there's a joint will and there is property, then how does the married or how do the married persons determine who the property is going to go to? So I'm happy to hear that it's not a requirement, but I'm still going to look into it.
yeah, and I will look into it as well a little bit. Like I said, it's not something that I've seen,
Mhm.
you know, but yeah, to look into it and a little more as well. And I could share any information and he could pass it on to
Okay.
the
No
members as well.
problem. Yeah. I'm almost done with my comments before we take the questions, and that is on insurance policies. And you mentioned that it should have a named beneficiary. And again, I have experience in that whereby when I would have taken out my insurance policies many, many years ago after high school, yes, insurance agents always guide you to put estate because if you put a named beneficiary at the time of application, then that named beneficiary, you need to get permission from them to change it. So I think the lesson here is for members to remember once estate is listed on the insurance policy, they need to go back to the insurance agent and have that changed from estate to a named beneficiary. In keeping with what you said, though, even when there's a named beneficiary, it means that should you want to change that beneficiary to someone else, you would have to get their permission. So, is that correct?
So no, so if you made the change after the insurance
Yes.
policy was approved, so you would have made the application, you put estate,
Yes.
right? Your policy has been approved. You're free to change the estate to the beneficiary and then change the beneficiary thereafter. It's not caught
Okay.
by, I think it's the Married Persons Act. It's not caught by that if you do that. So you can't change a beneficiary without the beneficiary's consent. Once the approval of the policy was made basically with estate before.
Okay.
Or it wasn't your spouse or your children, right? That you would have named in the application. Yeah.
Okay.
So that's why you put the estate.
Yeah.
You could put a beneficiary subsequently and you can change the beneficiary.
Okay. And you can change it thereafter without getting their consent. All right. My last question, what happens if an appointed executor does not have funds to probate the will?
Yeah, so will doesn't get probated, right? So, but it's in the interest, of course, of the beneficiaries to find the funds, right? Now, the thing about it, right? Because even if remember the executor can't access funds beforehand, so you could consider leaving a small account jointly with an executor, maybe if you know the circumstances. I mean, if you know that your family could probably manage it, right? Or maybe even if there was an insurance policy, so one of the beneficiaries may get some funds out of that, but you would have to consider in your case what it could be. Yeah.
Okay, I know that's a little ticklish situation with the executor and whether the executor should be informed, but okay, thank you very much. So let me go to the questions in the group chat. So there, just to inquire, the property would go to someone based on the terms of the deed. I think this was when you were sharing initially, Indira, joint tenancy or tenants in common. So let me just repeat that. This person is inquiring, the property, would it go to someone based on the terms of the deed, whether it is joint tenancy or tenants in common?
Yeah, so if there is a deed, right?
Yeah.
So a deed transfers property. So another point is with deeds, right? If a deed has transferred a property, so say if you have transferred ownership in a property by deed, you can't leave that property in a will now, right? Legally, that ownership has passed, right? You can't put it in a will, or if you put it in a will, it's just null and void. If in a will, the property has been transferred to you as a joint tenant with and it has, when you say joint, it means there's more than one person, right?
Mhm.
If it's transferred as a joint tenant, what happens is upon the first beneficiary's death, the entire property goes to the second, the surviving person. It's called, you know,
Yeah.
the survivorship, the rule of survivorship. If there are 10 people, it goes down the line until the 10th person, the last person is alive, and they will inherit, or be, sorry, not inherit, but be entitled to all the property, right?
Right.
The entirety of the property.
So in essence, it is important that in the deed, it is clearly stated whether it is joint tenancy or tenants in common.
Yeah, yes,
Mhm.
correct, yeah. And if
Okay.
there are no words of what you call severance, if you don't say tenancy in common, the law is going to, what you call, imply it's a joint tenancy.
Okay. All right. Thanks for that. Next question. How is a will made by someone who is in the early stages of dementia?
So, as I was indicating, in cases like that, you need to get a doctor to assess them, right? And doctors know about this certificate, right? Like a certificate of competency. So they will assess, does this person, notwithstanding the, early stage of dementia, has the capacity to, give instructions, well, in their right mind, to use
And if they are
an
not?
informal phrase. Well, they can't do a will.
Mm.
And that's why sometimes don't wait. Sometimes let's do a will while we can, while we have the mental competency to do a will, where there will be no questions, right? Because, when you do law and you study law, there are rules about lucid intervals, right? So they say they can make a will once at the time of making the will, they were lucid. But then who's going to prove that, right? So you don't want those issues kind of coming up where when the person, they may have very well, when they made the will, they understood exactly what they were doing. Because sometimes with these illnesses, there are periods where people think clearly, right? But you don't want when, the person passes, people are now saying, that's not true, that's fraudulent, auntie wasn't in her right mind, auntie X, Y, or Z. Yeah, so best way is to do it, as soon as you, you do it when you can, when no
Okay.
questions will arise as to your mental capacity.
Yeah, that it's unfortunate though, because I mean the member who is asking, I imagine that either the mom or dad has early stages of dementia, and what you are saying is that it's too late for them to make a will. So okay.
Sorry, just another note, a power of attorney as well, right? A person, has to have mental capacity to execute a power of attorney, right? So similarly, if you think, so sometimes too, if you're going to have something major surgery, major XYZ, you might be good to a power of attorney before, where say there may be some kind of incapacitation or if there's an illness where there'll be some degradation, of your mental ability, for example, or speak anything, right?
Yeah.
The ability to give proper instructions or to give written instructions, you try to do it while you have, the competency. To do it. Yeah.
All right. So this is a scenario. There is a bank account in my deceased dad's name only, sorry. The amount in the account equals to the fee that the lawyer is charging for probate. This means that there is nothing to be distributed when that is done. Is there a way to get access to the bank account without paying high legal fees?
Gosh, yeah. So this is a problem too, right? So right now, I think the limit might be $4,500, where you don't need a lawyer, you don't need an attorney to make an application. But if it's more than that, you would need an attorney. And so the candle costs more than the funeral. Yeah, so those are considerations as well. Yeah, I mean,
Mhm.
I don't know, you might have to look for a kind attorney, or I don't know if legal
Mhm.
aid, for example, if that would qualify, as something that they may take on.
Yeah.
So just important for us to consider, or if we have parents or loved ones, those kind of scenarios, best you join, you get a joint account with
Mhm.
that person. Yeah. Because a
Yeah.
lot of, and and some bankers will say some money just get left.
Yeah.
Because it's just not worth it. It's just not worth the expense of, having to go
Okay.
through letters of administration or probate. Yeah, but all the money is going to be taken up with, legal
Legal
fees, filing
fees.
fees.
Okay. Next question. What if an executor is a son and he hasn't shared the land after 20 years of his parents passing that was left for the said children? This is a real situation in a family currently. So let me read that again. What if an executor is a son and he hasn't shared the land after 20 years of his parents' death that was left for the said children?
Yeah,
So,
so you can take a legal action,
yeah,
against the executor for failing to execute his duties.
okay. So the family can take legal action against the executor.
Yeah,
Mm-hmm.
as well, if an executor has been delaying in filing for probate,
Probate. Mm-hmm.
there's something called a citation. That's another legal filing that the beneficiaries can do to force the executor to actually apply for the grant. Or the person entitled for, I think it applies for persons who have to apply for letters of administration as well. Yeah,
Okay.
so the persons or the beneficiaries can apply to the court to say, listen, you need to do this. Yeah.
Mm-hmm. Okay. Are trusts recognized in Trinidad and Tobago where the estate is left to a trust in a will?
So trusts are recognized. You can have a will and you create a trust. And an executor-in-law is a trustee, right? It's somebody who, property really is given for a specific purpose, stated purpose, and their obligation is to carry out that purpose in accordance with the instructions. Yeah.
Okay.
Yeah. People who have big estates sometimes, they may have more formal trust deeds, for example, yeah. They can do that, but
Right.
yes,
Yeah.
trusts are,
Okay.
trusts are recognized and trustees have obligations. Yeah.
Right. So I think you mentioned earlier that the average cost, I mean, give or take, to probate a will is about $1,500. This is one of the questions here. And it follows, why does it take years to get a will probated sometimes?
So preparing a will might start at 1,500.
It
The
might
cost of
start at
probating,
1,500.
yes.
Okay.
The cost of the probating a will or getting letters of administration is based upon the value of the estate. And it is it's actually prescribed. So the costs are prescribed.
Is
And
it like
unfortunately for
10% of the
us,
value?
I can't
Or
remember now. I
okay.
can't recall. Yeah.
Yeah.
It's something like, and I could always find it's the non-contentious. I don't know if I can't remember the name of the fees, but it's prescribed fees, and they are very old, like 1995. So they didn't keep up with inflation or whatnot. But even so, like I think I remember, doing a probate could be expensive, right? So I think
Yeah.
like a estate with a value of 500,000 could cost up, near to $10,000. Yeah. So
Okay.
that's why sometimes, you balance it in terms of, does it make sense for me to try to do a deed, try to do this another way as opposed to these expenses after, and then why does it take years? Good question. But yes, sometimes it's the efficiency of the registry.
Yeah.
Yeah, they deal with, as you can imagine, hundreds of filings, thousands maybe every year, tend to be backlogged. These, the documents are physically checked.
Yeah. Okay.
You have a clerk sitting down there. Sometimes there's inconsistency. Sometimes you file this, it's okay. You file something else, you get a query. they send queries, it takes time to answer the queries, it goes back in a line. So,
We need
it
to
could be
improve,
very
get that system
frustrating.
improved there.
It could be
Okay.
very frustrating. I think everybody is trying their best, but it needs to be improved, and any lawyers get blamed a lot. But, you know, yeah, it is tough. It is tough.
Okay.
Yeah,
Alright.
but
Okay, can any lawyer create a will, or should a member look for a lawyer who specializes in probates?
yeah, no, well, any kind of lawyer who does a general practice can do a will. You know, it's not, the requirements aren't difficult. So I won't say you need somebody specialized. Yeah, they just need to know the basics of the law, which they teach us. So yeah, and we have templates. Lots of lawyers have templates. So yeah, you should be okay, you know, once you go to, you know, once your attorney is competent.
Okay. So I have a question here. How are funeral arrangements to be paid for if the money is in the bank or the credit union? How is the person responsible for the funeral able to access the funds for the burial?
Now, from my experience is that banks will, once you submit the invoices, etc., they will disperse monies for funerals. Yeah, that is my my understanding. They will actually, give some money out of the person's account for funerals. If the person is in the NIS system, there's a funeral grant as well, which you can apply for. I told Paula, you all would know better. I know under, if you're a beneficiary to a credit union account, they will disperse funds up to a certain limit, but I don't know what's the time period for that. I don't know if it's quick enough to help with a funeral or not.
But I imagine if you present a death certificate to the bank or even to the credit union, I'm saying that guardedly, I'm thinking that you should be granted the basic amount for the funeral expenses.
Yeah, so that's sorry. Yeah, so with the death certificates, and I think they'll want to see the invoice, like a pro forma invoice for the costs or whatever from the funeral home. Yeah, my understanding is they will dispense once there is funds in the account to cover those expenses.
All right. Okay. All right. Can an executor to a will also be a beneficiary? And if so, isn't that a conflict of interest?
No, and sometimes it's pretty common. You might name your children, 2 children, as executors, and they're also beneficiaries. They just don't let them witness the will, because then they won't get the gifts.
Okay.
Yeah. Remember, the executor has a duty. So even if they are beneficiary, they have a legal duty to act in accordance with the will. So they can't just, I'm the executor and, you're supposed to get this, but I don't think so. And I will do this with it. Yeah?
Because you can take them to court, as you mentioned earlier.
Yes.
Okay. All right. So no more questions just yet. I'm not sure if there's 1 or 2 straddling along. If anyone wants to come off mute to ask a question, we do have some more time. Oh, sorry, I'm seeing that there are some questions in the Q&A. Let me just check that. Oh, I'm just realizing that. Some more questions, Indira. If a mother who is alive owns a house and one of her sons buys the land and she has other children, how can the house should or can be distributed to the other children if she wishes to prepare a will? Let me read that again. Oh, do I need to read it again or you got it?
I think I got it, but read it again. Read it again.
So if a mother who is alive owns a house and one of her sons buys the land, okay? So he buys the land, but she owns the house, and the mother has other children. how can the house be distributed to the other children if she wants to prepare a will? So one son owns the land and she wants to leave the house to the rest of the children.
Gosh, so that is a little tricky. So the law generally says when you buy land, you buy what's affixed on the land. Now, I'm not sure what the circumstances are where the husband, not the husband, the son bought the land so that the
Yeah.
title of the land is in his name, but the mother owns the house. I may have to get back to you on that, but generally speaking, when you purchase land, you purchase whatever is what they call affixed. You get ownership
Okay.
to whatever is affixed to the land. I don't know these specific circumstances. Yeah, but that is the general legal principle. But Paul, I could, check on that and
Okay.
get back to you if there is a scenario where now the mother can leave the house. So as we discussed before, and like I say, it's pretty common where people, they may have been on rented land or what you call
Yeah.
state lands, for example, they haven't been regularized, but they do own the house. You can
Right.
leave your interest in the house and you generalize it in all the premises situated so and so, including my house. Yeah, and you can leave it. You could name your
Okay.
beneficiaries. So whenever the time comes where, say, the land is being regularized, for example, those agencies will consider the will, and of course, well, you need to probate the will, right? But they will consider that as a, trying to not use a legal term, but a transfer of the property, once it's probated that, and they will put the lands in the name of the beneficiaries. But of course, he will have to go through a probate.
Probate,
Yeah?
yeah. And there's a follow-up question to that, and I think you mentioned it in your presentation. What if the mother then leaves the house for everybody, all the children, when she passes? Do you foresee any chaos in that?
Well, it depends, but for all the reasons we discussed, right? But I mean, at the end of the day, a person has to do what they feel is right for themselves and their family. So but you have to be mindful of, when I say real life, consequences or expectations, maybe. But it's up to the person who is, giving the house to consider that, right? To consider you want to leave everything and you want to do it equal, but, yeah.
And can you just recap for us the difference between joint tenancy versus tenants in common? So I'm just reflecting on the question that was just asked about a mother having 5 children, for example, and she's leaving the house for these 5 children and she puts joint tenancy. So it means that if one passes, it goes to the other 4 and then goes down to 3 to 2 to 1, whereas tenants in common is something. Could you just share with us a bit on that so we could make sure we understand
So
it
Paul,
properly?
so you're absolutely correct. So if I use some names of my screen, so if if Mommy Paula left a property to Marlon, Sheldon, Darvel, Rhonda, and Wayne, as joint tenants, say if Marlon passes first, well then the property, Marlon's family doesn't get anything. His share doesn't go anywhere. It goes to now Sheldon, Darvel, Rhonda, and Wayne. So now Sheldon, Darvel, Rhonda, Wayne are all,
and their
one
families
quarter
are there.
owners. One quarter owners. If Sheldon goes next, well then it's now owned by Darvel, Rhonda, Wayne. They all own like 1/3 each. Darvel goes, Rhonda and Wayne now own half each. Rhonda goes, it all goes to Wayne. Yeah, and if Wayne passes away, then well, Wayne's estate could inherit it. If you do a tenancy in common, and Marlon passes first, Marlon's estate. So if he had whoever his beneficiaries are, if he was married, his spouse, if he had kids, his kids would benefit from his 1/5 share. It would go to them, right?
So then it's better to do the tenants. At least what I'm hearing is that it is better to do tenants in common, because I'm just thinking if persons have their families and that person passes away, then it means that the estate or the family has nothing to get if it is joint tenancy.
Yeah, correct.
Yeah.
So it's a
Okay.
consideration for you to,
Yeah. Okay.
to make, right? But I've seen,
Right.
guys, I've seen where, oh gosh, and this is with huge estates, right? Where, and you know, back in the day, when I don't say that, right? It was common for people to have a lot of offspring, you know, some decades ago. So you might have had 10 children and, you know, you left it to the 10 children, tenancy in common, and but then the will was not probated quickly. And then people just start dying, people with lots of children. So it just, everything gets split, and then it gets very complex. So another thing,
Yeah.
get your probate done really quickly, right? Again, with people, if you have multiple children, one property, consider, I know sometimes it's a family home, but consider whether, you know, the house should be sold. And you could put in your will, maybe offer to a family member first, right? And the proceeds distributed. You could do
Okay.
that. Because it gets, yeah, it could get, like I
Messy.
say, yes,
Okay.
messy when everybody's trying to assert their ownership and their rights, and then somebody passes away, and then, oh, yeah, you know?
Right. So this is another question that we have here. I'm in a credit union. I'm in the credit union and wanted to have a joint account with my brother, but they don't have this function. Indira, I'm not sure if you'd be able to, I think I saw Kelly on. How do I get around that? Although I'm the executor, trustee, and power attorney. Let me read that again in case, just to make sure. I am in the credit union and wanted to have a joint account with my brother, but they do not have this function. How do
you
I
can't
get
have a
around
joint account
that?
in a credit union. I don't know, yes.
Okay.
So somebody from the credit union.
Is Kelly still
Yes.
on? I think I saw her earlier, but I'm not sure if she's still on. If not, Darvel, might you know? Okay. I guess we'd probably have to get back, get a response to, oh, Kelly is on, but she needs microphone access. Darvel, are you able to help? Okay, let me see if there are any other questions while Kelly is trying to get microphone
Hi,
access.
Paula.
Oh, hi, Kelly.
Hi,
Thank
Paula. Good
you.
night. Hi, Indira. And good
Good
night to our
night.
members. So the issue of joint accounts, so for our credit union, I know that there are some credit unions that have joint accounts. Based on our bylaws, we do not have joint accounts. So what is in place is essentially you can appoint a beneficiary. And then we are obviously governed by the regulation that upon death, we're allowed to pay out up to 50,000 directly to the beneficiary to go towards funeral expenses and whatnot. And then the balance would then be administered through probate of will or letters of admin. So it's really due to our bylaws and how we operate that we don't do the joint accounts.
So Kelly, just following up on that, would the beneficiary need to present the death certificate to get access to that $50,000?
Yes, absolutely.
Okay.
You would have to produce the death certificate and a
Yes.
copy of, if you have the deceased ID, as well as the beneficiary themselves would have to produce their ID for us. Once we verify everything, then we are allowed to pay that amount out to the named beneficiary.
Yes. Okay, that is definitely more than what the banks, I'm sure, would offer. So that is really good to hear.
And I'll take this opportunity to stress to our members the importance of assigning a beneficiary and even updating it regularly, because we've seen so many instances where it's a very old beneficiary. It was supposed to have changed. It never changed. Death comes and it creates a lot of, for want of another expression, confusion in that instance. And then there are also instances where members put things like trustee, and we can't do anything in terms of paying out the 50,000 if there's no beneficiary or trustee or estate put as the beneficiary. So actually having a named beneficiary is important, and even maybe being very careful in terms of how you appoint a beneficiary instead of just we've seen all kinds of things, Paula, you know, and instances like you appoint a friend as a beneficiary, and then a family member comes in with the death certificate and all of those things. So
Yeah.
it's really important to take the time to think about who is being assigned, but really assign someone as beneficiary.
Is there a limit, Kelly, to the number of beneficiaries you could have at the credit union?
No, you can have as many as you want. Once it's more than one beneficiary, you will then have to state the percentage.
Right, okay.
That
That was
that
my
being
next
said-
question.
That being said, we still can't pay out more than $50,000. The
Yes.
maximum is 50,000, and that 50,000 is then split. So if you've got one beneficiary, that beneficiary gets 50,000.
Yeah.
If you have 10 beneficiaries, then
It just
the
gets
50 is split
5.
between
Yeah,
the 10.
yeah,
Yes.
yeah, that's understandable. Right, okay. Yeah, so I am not seeing any other questions in the chat, so I think we can call it a wrap. Kelly, I don't know if there's any other thing you would want to mention as you're on regarding this. If not, then we would wrap up.
Yeah. Paula, just one more point, and it just
Yes.
something Kelly said just triggered. So as a starting point, encourage everybody that you in an email, right? If you don't have a will, list everything that you will be entitled to as you pass on. So whether it's you know, you have insurances in work, you know, and some insurance,
Yeah.
some workplaces have life benefits, for example,
Yeah.
your credit unions. So even if you don't give an account, you know, you say, I have an account at so-and-so, I have an account at this bank, I have unit trust shares, I have a Guardian Life,
Yeah.
you know, pension plan, I have these things. So just in the interim, while you preparing your will or considering it, if anything, I mean, and I have done this, right? And especially as things, you may have, something has come up, which, you know, you added on, for example, you make that list, you could email it to if it's your good friend or your spouse, so people will know when you pass on where to look for your assets, right?
That-
Because
yeah.
if not, part of the process, you know, you're writing all the banks in the world, you're writing everybody.
Yeah.
I represent the estate. Can you tell me if you have assets in the name of so and so? So to help and update that list and you know, I think it was Kelly was saying sometimes now you have to think about, right? So on this benefit, who do have the name beneficiary? Go back through it, find out. Maybe it needs updating. Maybe you know, you think it's somebody, but it's somebody else. Yeah. So as your
Yeah.
circumstances change, good to just take a check and do those updates.
Yeah, that is a good point, both Kelly, and a good reminder as well, because oftentimes when family members die, you know, the family members are clueless and they have to go
Yes.
searching. They don't know if they were in a credit union. They don't know if they were in a bank, which bank. So, right, good reminder. All right, so no more questions. Indira, I have to say thank you very much for your time, sharing your knowledge, reminders, new information on this webinar here today. I found it really insightful and I enjoyed the discussion. So thank you very much for that. I hope that I am echoing or speaking on behalf of the members rather. I would also like to say a special thank you to the SECU management team. We have Kelly Trabule-Hack, who you just heard from. She's the general manager. And her team, we have Adeline Ganis, and from marketing, and Davel Cordner, IT and other support. They are always there to support the education committee and other committees too. So I continue to say huge thank you to Kelly and your team. Just a reminder, those who would like to listen to today's session again, the recording will be uploaded in the library section on SECU's website, so you can access it anytime. We do have some upcoming initiatives from SECU. Next week, Thursday, the 24th, there is going to be a webinar on breast cancer. That is from 5 to 7 p.m. And we also have some exciting promotions. So look out for them if you haven't yet received them. There's a Christmas promotion where you are going to get twice your number of shares, and that goes until the 31st of December. And anyone who is interested in either taking a mortgage loan for themselves or their children, there are reduced rates as low as 4%, and those go until age 65. So do not delay, take advantage of the promotions that we have for you. And at this point in time, I would like to say thank you again for joining today's this evening's webinar. Enjoy your dinner, have a restful night, and continue to stay in touch with the credit union. Thank you very much. Bye.
Bye, everyone.
I've been with SECU for over 20. SECU has been assisted me throughout these years financially. I've benefited by being able to purchase my vehicle, my land, and my home. My family members are also SECU members. I've also benefited through FIP when in time of need to address my funeral expenses. This is my SECU story.
This is just one of